Here's the question that's popped up, something that recently came across my desk just in the past few days about something that had happened in West Virginia. If police officers have a search warrant for a residence, for a house, does that automatically mean that they get to search any individual who happens to be in that house? Does that mean that they get to confiscate any personal possessions belonging to any individual in that house, even if they're not a resident, even if they don't live there? What if they are just a guest who is visiting? So here's the basic rule, and that's that when executing a search warrant and a search for a premises and of named persons on the premises, police officers may not automatically search someone else found on that premises. So the general rules are that if they're executing a search warrant at a house, they can detain anybody who's in that house for a reasonable amount of time and in a reasonable manner. You can look at the case of Michigan versus Summers for that. They also can potentially do Terry frisks, pat downs, if they can articulate some, reasonable suspicion of why, somebody might be armed and dangerous or something like that. However, they cannot automatically just search someone else in the house if they're not named in the warrant. So first you look to the warrant. Does the warrant actually include names? Does it include the names of the residents? Now, it very well might include the names of the residents, but very likely, if we're talking about just somebody visiting, and that's really the issue I'm talking about here, if it's just a visitor, their name is probably not going to be in the warrant. And oftentimes what you might see, as was the case in this particular case, that there were no, well, I think there may have been a name in the warrant application, but I don't think the warrant itself had a name. So a lot of times the warrants don't have a name. They just identify the property that they're seeking to be seized, and it identifies the premises, the residence. So first thing we do is look to the warrant. What does the warrant say? Now, West Virginia, I don't think this really happens. I don't know that I've seen it, because they use, or here, the police use a form that's provided by the Supreme Court that has to be filled out by the judge who's signing the warrant. And it has particular language about what's to be seized. I suppose that could be changed. But some states, police have tried to issue warrants or get warrants issued that say we get to search everyone and anyone found on the premises. And this issue has been litigated about whether these types of warrants are constitutional. And these are known as all persons warrants. So cops have tried this in other places. Now here's the problem. We fought the Revolutionary War to get away from general warrants. And all of our case law, our Bill of Rights, our Fourth Amendment is geared towards the fact that police officers have to articulate particularized facts that apply to particular people, not just generalizations, not just general warrants. Again, we fought a war to get away with that, to get away from that. So when you have these sorts of warrants issued that say, look, anybody that's on the property at the time the search warrant is executed, you get to search them. The fact is that's likely going to be unconstitutional unless the warrant has particularized facts that explain why anybody in this space why there's going to be probable cause to believe that anyone in this space was committing a crime. Okay. There's been a split let me go to first. There was a Supreme Court case that you can look at if you're interested in this issue, and it's Ybarra. The case is Ybarra versus Illinois from 1979. And what this dealt with was the police officers in that case obtained a warrant to search a public tavern, as well as the bartender at that tavern, for narcotics. There was a state statute in Illinois that allowed police officers who were executing the warrant to search any person in the place to protect himself or to prevent the disposal or concealment of things particularly described in the warrant. There's no specific information giving officers probable cause to believe that anyone in the tavern other than the bartender was involved in the distribution of drugs. So the allegations in the underlying warrant application that the police officers filled out and the language in the face of the warrant said nothing about the establishment of probable cause to believe that everybody present on the premises is engaged in criminal activity. So it's a public tavern, so there could be perfectly innocent people in there. Now, under a different fact scenario, you could have like a mafia hideout that's not open to the public, and if you allege the facts adequately, there could be probable cause to believe that anyone in this mafia hideout is likely engaged in the criminal activity for which the warrant is seeking evidence. So public tavern, that was the Ybarra case. So no specific facts in there to establish probable cause for potentially innocent people who were in there. Yet the police got this all persons warrant that was going to catch and allow the search of anyone who just happened to be in the tavern at the time that they executed the search warrant. So basically they were looking for evidence that this guy Ybarra was engaging in drug transactions at the tavern, and that his presence in this tavern at a time when the police had reason to believe that the bartender was there, would be engaged in selling heroin. Now, let's see. The Supreme Court held that search of Ybarra was unconstitutional under the Fourth Amendment. Now, the court explained that there was no probable cause particularized with respect to Ybarra, and that this is an interesting word, his mere propinquity to others, and I think it's just a synonym of proximity, his mere propinquity to others independently suspected of criminal activity did not, without more, supply the missing probable cause. So Ybarra actually, he wasn't one of the ones that they were looking at that was supposed to be in this tavern. He was somebody who was not mentioned in the warrant, and he was searched under this all warrants clause. The U.S. Supreme Court went on and said that because of this particularity requirement of the warrant clause in the Constitution, a general warrant is impermissible, and it follows that a warrant to search a place cannot normally be construed to authorize a search of each individual in that place. Now, so that pretty much settles it, and the fact is that the cops cannot just search everybody who's there. Now, the Ybarra case did not say one way or the other that all person warrants are unconstitutional. They didn't even go there. So there actually has been a split in the federal circuits about whether or not, police can even use all person warrants. Now, the Fourth Circuit has gone with the majority view, as has the Supreme Court of West Virginia. And the majority view holds that an all persons warrant can potentially pass constitutional muster if the affidavit and information provided to the magistrate supply enough detailed information to establish probable cause to believe that all persons on the premises at the time of the search are involved in criminal activity. Thus, as long as there is a good reason to suspect or believe that anyone present, like my mafia hideout example, that anyone present at the anticipated scene will probably be a participant in the criminal activity occurring there, presence becomes a descriptive fact satisfying the aim of the Fourth Amendment. So a person's mere propinquity to suspected criminal activity does not, without more, give rise to probable cause to search that person. So it could be different. If there is, you would look first to the warrant. Does the warrant say that the cops can search anybody that's present on that premises? Now, if it does, you would look secondly to see what jurisdiction you're in. Because if you're within one of the minority jurisdictions, they hold that you can never perform all persons. You can never issue, judges can never issue all persons warrants, and therefore the cops can't execute them. But if you're in one of the majority jurisdictions, then you want to look to the case law of your particular circuit and your particular state, such as in West Virginia. And they're all pretty much like this, that, well, they could potentially pass constitutional scrutiny. However, they have to be up to par. They have to explain why this is a mafia hideout situation and not a public tavern situation. It has to be clear in the warrant affidavit that underlies the warrant, and in the warrant itself, why anybody who might be present at that time is a suspected criminal, essentially. And if it doesn't, that's the sort of general warrant that our Constitution does not allow. And I can't believe that this doesn't come up more. But when the cops are executing a search warrant, I get asked this a lot. Yes, they can handcuff you for a reasonable amount of time. Unfortunately, I disagree with that. Another unintended consequence and byproduct of the war on terrorism. But they can handcuff you. They can potentially pat you down, but they can't necessarily take your stuff. They can't take your laptop that you have with you. They can't take your phone out of your pocket, out of your hand. If the warrant does not name you, if the warrant does not describe you, if the warrant is not an all persons warrant that adequately explains why anyone there must be a criminal. So just in this past few days where this happened, this did actually happen in West Virginia, and law enforcement was not aware of this. They weren't apparently taught this stuff. That just because you have a search warrant doesn't mean that you can search anyone in the residence, that you can take anything in the residence. You have to follow the language of the search warrant. So even though the cops may have a legal search warrant, they may execute that search warrant in unlawful ways. And when they exceed a search warrant, that in and of itself is a civil rights violation. And I've explained this before, that if the search warrant is looking for a stolen car, they would be exceeding the scope of that search warrant to go look through dresser drawers upstairs, unless they're legitimately looking for keys or something like that. If they're looking for human beings who are being trafficked, that doesn't necessarily entitle them to look in a backpack. So you have issues there of whether the execution of a search warrant could exceed the legitimate scope of the warrant. Then you could have other issues. Even though you have a legitimate warrant, those can still be attacked, and that's a different video. But you have this line of case law coming from Franks versus Delaware that allows you to actually look at the underlying warrant that the police submitted to the judge to get a warrant signed and examine whether or not there were misrepresentations in those warrants. And under some circumstances, it's possible to get a warrant thrown out. It's being based on lies, being based on material omissions, being based on misrepresentations. And I was actually planning on doing a video on that. But as far as this issue is concerned, that's what the law is. And a lot of people, even in law enforcement, don't understand it. Just a search warrant does not entitle law enforcement to search everyone in the house. It doesn't entitle them to seize everything in the house. Okay? So there's still and always needs to be probable cause to support a search.